Hey everybody, I'm going through my second binder now, and what this says is I'm addressing how and why the current orders are void, not voidable, but actually void, meaning they're without legal effect, not capable or incapable of enforcement, and why anyone enforcing or acting upon them would be a by law trespasser and actually engaging in personal criminal, color of law, illegal arrest, attempt, and imprisonment. This is why I'm actually abiding by the law and keeping Mariah safe. So I'm going to go through this as quickly as possible. She's taking a nap right now, so I'm going to try to hurry up and blaze through this. I'm also getting tired of talking and telling a 3-year story. It's wearing on me, but I need to get through at least the 2 other binders that I've prepared. So in this binder, what I'm covering, the subject matters are, in number 1, judicial mandates, and also how judges can lose jurisdiction or power. Number 2, and again, all of this, I just want to make a disclaimer, I'm not giving legal advice. I'm using my First Amendment right to be able to tell my story and how these particular things, how I interpret them and how they pertain to my case. So I just want to make sure that I put that disclaimer out there. Number 2, attorney mandates, misconduct and collusion. Number 3 is enforcement, the requirements to not be void and also to be enforceable. Number 4 is addressing the physical, emotional health, welfare of a child, and particularly under Texas law, a child under 3. Number 5 is the CPS Penal Code and Texas Family Code, duty to protect regarding children, the parents, or the consequences if you don't. It should be interesting when you read about that. Number 6 is going to be about void orders in this and these matters pertaining to me and my family, being perpetuated under cause number 470-52517-2014 there at Collin County. Again, one that should also be linked and requested and sought after is 470-54633-2015, which was the protective order that I had to file during the pendency of this suit on August 20th, 2015, that the county clerk secreted into a different case number. All right, number 7 is addressing the 470th and other conspirators, trespassers, and criminals violating the law in this case. Number 8 is a little bit about the murder threats, motive, conspiracy pertaining to the things that are noticed to the court that they're aware of and fully not protecting or defending in my right to equal protection under law, but going along with and colluding with. 9, we're going to touch on a little bit of the housing instability causes and defenses, claims, and also just how Collin County corruption and bias against me has contributed to our losing 2 homes that we shouldn't have lost, and now putting us in a situation where getting housing is difficult, very next to no ability to do so, and having to be in a 2-bedroom suite that is very much considered residences. The signage, budget suites, is residences. We sign leases. Again, the only difference is you're not getting approved to be locked into a lease for a particular portion of time. But again, how Collin County has helped to create that crisis, and then now wanting to move forward to try to give him custody of her, ignoring all of the crimes, abuses, and other issues pertaining to, again, the penal code, the family code, and everything else. I'm going to talk about that for just a little bit. We're going to talk about number 10, how I'm not engaged in a conspiracy theory, but just the history repeating itself and deja vu as to why the Holy Spirit told me it's time to go. Take her, tell the story, get the truth out. I'm stepping into the courtroom, about to render my verdict. Ultimately, this is talking about how this exact same situation with writs of attachment being issued out of family courts there in Collin County. Not jumping the gun, I'm not fearful, paranoid, but this actually happened to me before with my son. So this is how history is repeating itself, and this time it's not going to end the way it did before. The 11th subject matter here is Collin County Police and CPS cover-ups, the color of law, colluding with them. And then number 12, what I believe is the solution or the call to action. So I'm going to go through this really quickly, and first I'd like for you to meet my criminal judge, trespasser of law, Emily Miskell. She is actually known as a family law specialist for a family court. This is actually coming from her website, miskellforjudge.com. I'm going to go ahead and read what it says. It says, about Judge Miskell, a family law specialist for a family court. Here's her nice little picture there with Greg Abbott, governor. Judge Emily Miskell was appointed by Governor Abbott as judge of the 470th Family District Court of Collin County, Texas. Judge Miskell received her law degree from Harvard Law School and is board certified in family law by the Texas Board of Legal Specialization. She graduated from Stanford University in the top 15% of her class with a Bachelor of Science in Mechanical Engineering. She has served as an adjunct professor of family law at the UNT Dallas College of Law. Judge Miskell is a conservative Republican who believes in the rule of law and a strict interpretation of the Constitution. As a judge, she commits to faithfully adhering to the Texas Constitution, the United States Constitution, and the Texas Family Code as enacted by our legislature. She strongly disapproves of judicial activism. She will work to uphold the values that keep families and communities strong. All of that sounds great. When I saw her website, I was very encouraged that there might be hope of all of that coming to Collin County. But again, it's a great campaign website. Political advertising by Emily Miskell. Here's a picture of her and her husband and her sweet little baby girl. It says Judge Miskell is a member of many legal organizations, including the Texas Academy of Family Law Specialists, the Henderson Inn of Court, the Collin County Bar Association, and the Collaborative Law Institute of Texas. She was selected as a fellow of the Texas Bar Foundation. Okay. All that sounds really good. I know. Baby girl, I'm kind of tired of it too. All right, so now we're going to go ahead and go to welcome to judgesabovethelaw.com. I thank y'all for this website. I'm going to go ahead and read just the cover page to explain just ultimately in a bullet what's going on. This is by far the best judicial corrupt system description on what has happened and is happening to me and my children in Collin County and being blacklisted from justice. And so I'm going to go ahead and talk about this case. This was a case that was filed May 8, 2016, but it says why this case matters so much to so many. It says, imagine one day you or someone you love find yourself wrapped up in some unexpected litigation, whether civil or criminal. Statistically speaking, everyone in America will at some time in their life be a party in a lawsuit. Here's a little background. Until 3 years ago, R. Michael, R. Catherine truly believed courtrooms were places where judges listened to the facts carefully and decided cases honestly. Then she got the lesson of his life. Then he got the lesson of his life. A judge in his case could and did cheat. Opposing counsels could and did cheat. And once they coordinated their cheating, no fact, law, or procedure could save him. He was set up to lose. When you think of a corrupt judge, you may think of one who trades rulings for cash. As far as we know, that obvious sort of corruption is rare. You must appreciate, however, that corruption may take subtle but equally destructive forms. Among other things, a dishonest judge can ignore evidence, twist rules and procedure, obstruct the record, retaliate, manufacture facts or ignore others, allow infirm claims or dismiss valid orders, deny admission of evidence prejudicial to the favored party, suborn perjury, mischaracterize pleadings, engage in ex parte communication, and misapply the law. When he or she does these things intentionally, motivation is a separate issue, he or she commits a crime. Petty or grand, the acts are still crimes. It takes surprising little to steer a case. After the American Revolution, our Constitution was conceived and adopted as the mechanical foundation of our government. For ordinary citizens, the independent grand jury was the only tool of salvation from judicial corruption. Without this critical tool of redress, American civil rights exist only at the will of a judge. That tool, unfettered access to a grand jury, has been taken away. Judges simply snatched it from us. They did it by enacting judicial legislation, by ruling that private citizens had no right to access to the grand jury. They took the grand jury from us and they gave it to themselves, and they used their gatekeeping power to protect themselves from accountability all the time. Who decided what will be the law? Judges did. Who is supposed to decide what will be the law? Congress is. Right under Congress's nose, the entire judicial branch of our government placed itself out of reach. They eliminated all means to be held accountable to the public for their actions. Judges are now above the law. Federal judges and federal prosecutors routinely block the access common citizens are supposed to have to the federal grand jury. There is a logical but not legal reason for this. If you've ever seen someone hustled through the courthouse cattle chute, you'll understand that equity and justice have little to do with the process. Judges can be determined to make things turn out the way they want them to, and naturally, prosecutors are always determined to get convictions in many ways. Equity, justice, facts, and law interfere with the process. Have you ever stopped to consider that public defenders, the poor man's lawyer, don't investigate anything? Public defenders do not have police or detective resources at their disposal. Only prosecutors do. Your defense will rely almost entirely upon the evidence the prosecutor decides to share with your lawyer. If the prosecutor forgets or loses evidence, of course, both of those, quote unquote, that would help your case, or decides to ignore an important lead, he will win and you will lose. That is not merely misbehavior. That is criminal behavior. The very last thing a prosecutor or judge wants is a properly operating independent grand jury. The only recourse that remains now against a corrupt judge is to respectfully request that judge to evaluate himself for honesty. I had to laugh out loud on that one. What criminal wouldn't desire the power to block an investigation of their own crime? It is hard to imagine a more fundamental or structural conflict of interest than that. I'm going to go back now and read. Apparently, this was done to read up and down based on the paragraphs. So, let's see. I'm going to go ahead and read here. It says, therefore, citizens have no choice but to literally pray to a judge for leave to assert their rights. Where their prayers are denied, their rights are denied. This type of abuse is exactly why our forefathers granted ordinary citizens the right to access the grand jury directly. It is a centuries-old system of checks and balances, imported from England, installed in America to protect ordinary citizens against judicial tyranny. Direct access to a grand jury is the victim's path, us, around the victimizers, bad judges, roadblock. Again, not all judges, corrupt judges. In this petition, you will see a perfect example of justice thwarted by the very people, judges and the U.S. Attorney, who are supposed to ensure that justice is done. I, Catherine I. seeks to expose and eliminate this unfair conflict of interest. Why did the Seventh Circuit try so hard to bury his case? Because to allow a common citizen direct access to the federal grand jury is to expose the judiciary's Achilles heel, accountability to the people. Title 18 U.S.C. 242 provides that judges are liable for criminal acts committed under color of law, meaning that judges may be immune from prosecution for civil misbehavior, but they are not immune from prosecution for criminal behavior. The only way to make a judge answer for criminal behavior is to bring criminal charges against him. The ultimate irony here is that the only way to bring criminal charges against a bad judge is to ask another judge for permission to pursue the bad judge. As noted above, that will never happen. As long as the subjects of the investigation, judges, are the gatekeepers of the investigation, there will be no investigation. Therefore, judges have rendered Title 18 U.S.C. 242 unenforceable. IFB, Catherine, and I cannot win this fight to bring evidence of judicial misbehavior directly to a grand jury, then all Americans who are victims of 242 crimes are denied their civil rights. It will become forever impossible to get a complaint against a judge past a judge. This is why his complaint matters so much to so many, because you never know if the judge in your case is going to do his job. If he or she decides to steer the proceedings against you, you will wrongly lose your property, your liberty, and perhaps your life. You must have a way to protect yourself. Read our Catherine's iBooklet to understand how this barricade affects all of us in ways you would never suspect. Call your congressman today. Tell him to tell the Supreme Court to answer this question. Does an American citizen have a constitutional right to petition the federal grand jury to investigate crimes committed against him? Does an American citizen have a statutory right to petition the federal grand jury to investigate crimes committed against him? Do members of the executive or judicial branches of government have the authority to block access to the grand jury? This says, view all documents, including the writ of certiorari, brief summary of the case. We need your help. Sign our petition and support. This was federalcase@gmail.com. Email this page to a colleague. Judgesabovethelaw.com. I'm thankful for that description because, again, if I can just go back to what has happened in my case over the past 3 years, I'm going to read this one paragraph. Among other things, a dishonest judge can ignore evidence, twist rules and procedure, obstruct the record, retaliate, manufacture facts or ignore others, allow infirm claims or dismiss valid ones, deny admission of evidence prejudicial to the favored party, suborn perjury, mischaracterize pleadings, engage in ex parte communication, and misapply the law. That in a nutshell. Of course, not including how they're secreting, covering up, and colluding with, and finally have legally effectuated what is necessary for Creed Johnson, my daughter's father, to get away with murder and be turned over our daughter. I've got to add that to the mix. So the murder conspiracy, intentional, willing, knowing conspiracy for that. That's what we've been dealing with for the past 3 years. That's why Truth Judge Jesus has me out here on the road. This is just a copy of that, looks like Supreme Court. I don't know if this is a writ of certiorari or what this is. Yes, petition for writ of certiorari. So I just put that in there. I talked about when I was filming this wall of all the steps that it's taken for us to get to this point where I was forced to literally run for my life and also to protect my baby girl. I talked about how on Facebook I had made a comment about everything I had read about Judge Miskell and how I was hopeful that after this whole fraudulent Mother Didn't Appear thing for October 2nd, 2015, based on her campaign website, that she'd do the right thing. And so on Facebook, I actually went and I made a comment sharing on my Facebook page Judge Miskell's formal investiture to be held October 23rd, Friday, 1:30 p.m., Collin County Courthouse, McKinney, Texas. It said 41 guests. I actually responded to that on my page. I think I shared it on my page and wrote on it. I don't know if it was on her particular site. It wasn't, because I shared the event. I didn't do it on her page, but I shared the event, which means I guess she gets to see it. And this is what I wrote. My website, again, is Marlena A Better Me Yvette. Judge Miskell is a conservative Republican who believes in the rule of law and a strict interpretation of the Constitution. As a judge, she commits to faithfully adhering to the Texas Constitution, the United States Constitution, and the Texas Family Code as enacted by our legislature. She strongly disapproves of judicial activism. She will work to uphold the values that keep families and communities strong. And of course, www.miskellforjudge. And then I put hashtag defining moment. Let's see how much she truly means this. Smiley face, verdict's out, signed order, or notice of hearing for new trial. Again, I had filed immediately when I approached the courtroom and found locked doors, and then went to the district clerk's office and realized that she signed a default judgment stating Mother Didn't Appear for the motion to modify possession and access filed by Kenneth S. Harder of Carrollton, Texas for Creed Johnson. That again was a groundless frivolous suit to modify a 4-month-old order. Again, I had filed a motion to modify. It also emailed a letter. E-filed a letter to Judge Miskell to explain everything that had gone on with this case and why ultimately, please, I need to have a hearing and an opportunity so that she could properly apply the law before just signing an order that would violate due process, the U.S. Constitution, the Texas Constitution, and my rights. And so I placed it on Facebook. I didn't know originally that they saw that, but apparently it was scanned in on 10/6/2015 at 11:21 a.m. Whoever's handwriting, it looks like Mallory Maddox's 470-52517-2014, which is our cause number. It states in the interest of Mariah Sorey Yvette, Jonathan Lewis, Joshua McDaniels, and Jeremiah McDaniels, which is interesting because they all have 3 fathers. And so if this suit actually covers all of them, where their father's participation in the suit was and where they have been able to be included during the pendency of the suit, I don't know. That's kind of a big issue. And ultimately, that response and it being filed. So here's the file stamp. Apparently it got filed October 15th or October 5th of 2015 at 12:33 p.m. Looks like judicial activism to me. I don't know. Maybe she just didn't like me to bring light to that. It looks like the person who filed this was Anna something, deputy. And ultimately, here is now a copy of the letter that it says, from the desk of Marlena Yvette, pro se litigant, custodial parent in the interest of Mariah Sorey Yvette Johnson. My information there from the Texas Crime Victims Address Confidentiality Program, Marlena Yvette, VA 150963, PO Box 12108, MC 068, Austin, Texas 78711-2108. Again, as a Texas Crime Victims Address confidentiality participant. That was my address. I sent this letter to her October 6th. I can show that it was e-filed again October 6th, 2015 at 1:18:05 p.m. It says Andrea S. Thompson, District Clerk, Collin County, Texas, by Laura Edwards, Deputy. Envelope ID 7249474. Good picture so you can see all that. So the title is Letter to Judge Miskell regarding proposed orders and motion for new trial and motion to modify and protective order hearing, as well as motion for enforcement October 2nd, 2015 scheduled hearings in the interest of Mariah Soraya Yvette, which is cause numbers 470-52517-2014 and 470-54633-2015. This has already been scanned in, so you want to see this letter. In this letter, I ask her to take judicial notice and also request an opportunity to have the hearing. Again, this one, it looks like the same Anna, again, certified record. There was another letter that I made. Now, this one was filed November 2nd, 2015 at 6:05 p.m. Andrea Thompson, District Clerk, Collin County, by Lacey Landreth, it looks like, Deputy. Envelope ID 7630311. This is my November 2nd, 2015 update letter to Judge Miskell, post-filing and appearing 10/16/15 and 10/30/15 regarding TRO applications / letter to Judge Miskell regarding proposed orders and motion for new trial and motion to modify and protective order hearing, as well as motion for enforcement October 2nd, 2015 scheduled hearings in the interest of Mariah Soraya Yvette, with cause numbers 470-52517-2014 and 470-54633-2015. So again, I'm writing and giving her the opportunity for all judicial notice, making a request with regards to all the facts of the case. Again, received the certified copy from the District Clerk's office. Now we're going to talk about the Code of Conduct for United States Judges. Yes, they actually do have a code in which they're supposed to abide by it. They don't get to do whatever they want to do, although unfortunately too many judges today do. Again, there's also good judges, but we're talking about a bad judge right now. We're talking about a corrupt judge and company, and how we've gotten to the point where now I was forced to just stay safe for my life and also for my baby girl's protection from this conservative Republican that commits to upholding the Constitution and applying the law appropriately. So now we're talking about Canon 1, a judge should uphold the integrity and independence of the judiciary. A judge should avoid impropriety and the appearance of impropriety in all activities. So it talks about all the various different canons. You can go to uscourts.gov. Looks like my baby girl is woken up. After the final hearing on March 2nd to sign the orders currently that they're trying to enforce and hold me in prison in her writ for, I filed what they call a Federal Younger Doctrine Alert. If you Google FCLU for Family Civil Liberties Unit, Federal Younger Doctrine Alert, you'll realize what this is. But that was letting the courts know that they are continuing to, it says in particular, the sheer amount of ongoing bias, prejudice, and fraud within this case, perpetuated in order to actually aid, abet, conceal, and cover up repeated and continual acts of abusive process, breach of fiduciary duty, tortious interference with prospective relations, intentional infliction of emotional distress, and vicarious liabilities of criminal acts by an employee by respondent upon the minor child herein is not only grossly disdainful and ghastly, but is indeed criminal. And this is when I filed my Federal Younger Doctrine Alert. I'm going to stop right here. This is just showing the e-filing for 11 to 6:05 a.m. request for a rehearing. Okay, baby, we're done.